The next matter to come before the court this morning is in re T.B.W. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve that time and let me know ahead of time when you get started, I'm keeping the clock this morning. The court's read the briefs and are ready to see when you are.
Good morning, Your Honors. My name is Attorney Connie Hightower. I represent the mother in this case, the appellant. I'm asking the court if I can please have 3 minutes for rebuttal. And I'll start first with a brief recitation of the facts. This is a permanent custody case that came out of Summit County Juvenile Court. It's a little bit different from some of the permanent custody cases that we may see that are on the 2-year track, where a parent has not necessarily rectified any situations that deal with that have given rise to complaint. In this particular case, the mother, Raisha Primes, this was her second CSB case. The first case did not result in the removal of a child. That first case was from 2010. She has a child who was 5, and she had it with the child's father, who is now incarcerated. The child's father was incarcerated because he severely beat the mother, severely beat the child, and he beat the mother so badly that it caused the loss of her unborn child that I believe was 8 months at the time. So he's serving a 20-year sentence. Father in this case was convicted in January 2014. Prior to his conviction, he still did not have contact with the child in this case. What makes this case unique is this case went through shelter care, adjudication, and disposition. Disposition occurring September 16th, which is when the case plan was adopted. Mother began, and I don't think that in fact, I even think in the state's brief that the state agrees that mother began working her case plan. She was working her case plan diligently, as the case worker said. But they believed that mother needed mental health counseling. She had experienced abuse at the hands of this man for a significant period of time. And there was testimony that mother was going through the cycle of violence and battered woman's syndrome. The state referred mother, or the case plan asked mother to do mental health counseling, parenting assessment. This wasn't complete until December 2013, which was a few months after the case plan was adopted. At that point, she was not referred to any counseling, which was a part of her case plan component. Mother then started counseling in March of 2014, which was the same month that the state filed for permanent custody in this case. The reason why I say that this case is unique is we all understand Troxel v. Granville, the fundamental right to parent. We also understand that our state has put requirements in effect in 2151 as to what we need to do to preserve a parent's fundamental right to parent, even if that parent was adjudicated, even if the child was adjudicated dependent, abused, neglected. This particular case, this mother, the state filed for permanent custody 6 months after the case plan was adopted, the same month that mother began her counseling. So it makes it a little bit unique because it's not the 12 out of 22 type of case that we've seen. This is a case where the parental rights of mother are going to be terminated in a lesser period of time when we haven't even gone to that first 1-year mark. As to the fact,
don't have to wait till that time.
I agree, Your Honor. I agree we don't have to wait till that time, but I think it goes to at least what our first assignment of error is addressing, which is the reasonable efforts. If we're not waiting until that one time, and we understand that parents should have the right to, fundamental right to parent, and that children should have the right to be with their parents, I think we need to look at what efforts are being made on behalf of that parent before we decide we're going to terminate their parental rights prior to that 1-year mark. So I do agree it's not required. There are certain circumstances, but we believe that this case doesn't meet those circumstances. Namely, as it relates to the first assignment of error as far as the reasonable efforts that CSB would have made. And I'll kind of tie that a little bit into the 6-month extension that Mom had asked for. In this particular case, when CSB had filed the motion for permanent custody when Mom began counseling, her counselor testified she had continued counseling despite the filing for permanent custody, and at the time that the trial was held, Mother had already completed about 40% of her counseling goals. So they had 5 sessions with the counselor originally beginning in March. So by about April, they had determined mom's counseling goals. She had already, by the time of the permanent custody trial, had already reached 40% of her counseling. At no point in time did her counselor who testified say that she could not work towards those goals and could not be rehabilitated, or that her counseling would be significantly long-term. The only person who testified as to what her counseling or the length of her counseling or whether she could be reunified with her child was the caseworker. And I think it's important to note that the counselor who wrote the assessment wasn't there. This was just mom's counselor. The caseworker was the one who said that she didn't believe that mom could successfully complete her counseling. That wasn't the testimony of the counselor. And so one of the arguments is that we believe that mom should have been allowed to continue that counseling to see if she could get past the cycle of violence. We do not dispute that mom had some issues she had to get past, that she did have to acknowledge what happened to the child, that she did have to acknowledge the trauma she experienced and the child experienced. And these were things that she was actively working on. The counselor was very pleased with her progress. When we link
I'm sorry, the counselor was what?
pleased with her progress.
And where would we find that in the,
I believe it was cited in my brief, but let me double check and look and see here. I know the counselor's testimony is around page 38. And
well, did the counselor acknowledge the difficulty the difficult situation that the mother was under, and specifically indicate why she felt this was, the mother was capable of, in a timely manner, recognizing the true danger that her child was in?
the counselor, I don't believe that question was ever posed to the counselor in that manner. What was posed to the counselor was that what mom still had to work on, and she said that mom was working on just those things, being able to understand and recognize the true risk, and those were things that they were still working on. That would have been the part of the progress that mom hadn't gotten to, but she had only been in counseling for about 3 months at that point in time. So I don't think it was ever asked to the counselor in that manner. Just briefly, the other things that we were concerned about as far as the reasonable efforts that the agency made. Mom did have a place to live. Mom had been employed. She lost her job. She was still seeking employment. She was visiting with the child. The child and she were very bonded, had a very good relationship. And the child's counselor also talked about the trauma the child had, but that he was a very angry little boy who would need to, it would greatly affect him if his mother was ripped out of his life, essentially.
How long was she in counseling when she was still allowing the contact with father, between father and child?
I believe maybe 2 months. So at the time that the PC occurred, I think that the contact was like 2 months before the PC hearing that she had allowed.
And she had been in counseling 2 months or so?
I think she was she had begun her counseling for 2 months, but she was probably only in the meat part of it for about a month because they had 5 sessions of developing the plan.
Well, certainly in the development of the plan, it would have included the basics, which were no contact, et cetera, et cetera, et cetera.
And I can't assume that. I do know that the doctor listed what things they went over, and one of those were the risks to her child. One was coping skills. But I can't say, and I don't think the doctor testified as to whether or not they talked specifically about that no contact, in and out.
And she testified at the hearing?
The doctor...
No, the mom.
The mother did not.
So, okay. All right, that's fine.
Some of the other issues that we were talking about as far as the reasonable efforts was the fact that father's incarceration did not occur until January 2014. At that time, that's when reasonable efforts bypass was sought. We understand that the state's argument is that mother didn't object to reasonable efforts bypass, but certainly even though father is an abuser, until he had the conviction, there was no reasonable efforts bypass, and there should have been reasonable case planning services that would have involved father and or father's family.
Had she raised that?
Had she raised that father was not included? I don't believe she raised that at the time. No. As far as case planning, then also the case plan that was presented at the hearing was the one from June 2010, which would not have, which had changed objectives in it, and that one would not have allowed enough time between the permanent custody trial about 6 weeks later and when the case plan was first given to the parties. And so we think in fairness, if we are going to do reasonable case planning, that the case plan that the parent is working on at the time that the PC is filed should be the case plan that's being reviewed to see whether or not that parent has met the requirements under that case plan.
At the time of the PC, there was also pending mother's motion for a 6-month extension. But that's not assigned as an error in this case regarding the denial of a motion for a 6-month extension. Is there something in there? I mean, it appears that the reasonable efforts argument is we didn't have enough time, not that you weren't doing what, not that you weren't doing what you're supposed to do, we just weren't given enough time.
Your Honor, I think in the assignment of error number 2, as to the manifest weight of the evidence, I think that addresses both the fact that mom filed the 6-month extension as well as guardian ad litem's position and the state's position. So all of that was included into the manifest weight of the evidence for the court to decide what they decided, because certainly at the court's disposal was both the state's motion as well as mom's 6-month extension motion.
And please refresh my recollection. What was the guardian's position on the 6-month extension?
The guardian was not in favor of the 6-month extension. She wanted stability for the child and felt that there wouldn't be stability for the child. And we did note in the brief that the guardian didn't talk about mental health, didn't talk about any of those things that perhaps the court might have talked about. Hers was more based on stability of the child and didn't address whether or not a 6-month extension would harm the stability of the child. Your Honor, am I close to my...
You are 3.5 minutes, I just got to tell you.
Okay, I'll stop here and then I'll rebut. Thank you.
Excuse me. May it please the court, Richard Cassay representing CSP in this case. There was a question, I believe, from Judge Carr about when the phone contact or when did mother start facilitating phone contact between the child and the father. That began in October of 2013, and I believe the mother was in counseling at that point. As far as a 6-month extension, no, it is not separately assigned as an error, but under the precedent from this court, if permanent custody is in the best interest of the child, then by definition, a 6-month extension is not in the best interest of the child. So more or less, the 6-month extension argument is subsumed in the best interest factors analysis. Now, there was a comment made that the case plan was changed. The only change from the initial case plan was that mother was to maintain employment rather than seek it. So that's hardly an added objective that presented some kind of insurmountable obstacle to this mother. The main point of this case, and it's a constant refrain, the mother, when the prior DN case ended, there was a no contact order protecting the mother and the child from father. Mother let the father into the home. The result was he beat both of them to the extent that the trauma counselor said that was the beating, the injuries were worse than 98% of the cases she had ever seen, including that the father killed the unborn child, resulting in him currently serving 20 years to life in prison. Now, what does mother do about this? Well, she consistently denied what really happened. She said this child went to the playground with the father the week prior, and maybe the child hurt himself there. the most ever mother got to acknowledging the role of father's violence in this case was, she said she started beating herself. And then when father saw her beating herself, he joined in and beat her himself. What did mother do then? She's severely injured. She leaves the home, she leaves the child who was severely injured with the father. So this is the background where this case is originating from. Now, through the course of this case, mother's counseling, the main point was good decision making. You have to recognize the environment, the harm that this child has suffered, and you have to be able to recognize those types of relationships, unhealthy relationships, in the future, so you can protect your child. Because when we come down to permanent custody, for all the talk about fundamental rights, the Supreme Court of Ohio has made it crystal clear the best interests of the child control and not the fundamental rights of the parents, and that's in Re B.C. But what does mother do? She facilitates phone contact between the father and his child. She lies about it. First she says she's talking to her brother. Then when that's proved to her to be a lie, she was sleepy, but she does it. The effect on the child is, in the foster home where he was currently placed, he becomes extremely aggressive, acting out, and he acts like he wants to burn the family's cat up. He's pulled out of that home, put into the relative's home. There's no improvement. The phone contact continues. He's taken out of there. He's put into the current foster home, and the phone contact ceases, and his behavior dramatically improves. That's one of the worst things that this mother did. The other, and even maybe worse, she tells the child, do not talk to your counselor. That's Keck McNulty. And the child tells Keck McNulty what the mother has done. Up until that time, now this was a difficult child to work with because of what had happened to him, but up until that time there was slow and steady progress being made. Dr. Keck McNulty said it had progressed to the point where the child would take my hand and walk down the hallway. So mother intrudes and tells the child, stop talking to her. And what happens? The child's relationship with Dr. Keck McNulty deteriorates to the point where he will not talk to her, and he's acting out again, throwing chairs. So, this mother, in CSB's view, is in a very poor position to claim that this permanent custody decision is against the manifest weight of the evidence. Mother has problems, there is no doubt, but her problems are not the focus of this case. She needs counseling if she is ever going to have any type of enjoyable life. She may not want that. She has a dependent personality. She needs somebody to support her. Her choices in that regard have not been good. That's on her to improve. But during the course of this case, she has shown without any doubt that she has not recognized that her responsibility is to this child. I pointed out two what CSB believes are grievous malfeasance on the part of the mother, and really, I think that's the point of this case. For all the counseling she's had, she had not progressed on the main point of what Dr. Vittori was trying to do for her. Reasonable efforts. The trial court found the E1 factor, and while this court's case law is maybe not 100% consistent, The later case law appears to require some proof of reasonable efforts, even though in general, at a permanent custody trial, CSB is not required to prove permanent reasonable efforts. But there were reasonable efforts. She was referred to a parenting evaluation. She was referred to a counselor. And I'm getting this from the GAL report, she applied for AMH housing, and even there, she lied because she told AMHA that the child was going to be living with her, long before this case had come to any type of conclusion. She has a job. She has a temporary staffing job. Her income is minimal, and again, from the GAL report, from the small amount of income she's getting, she's giving 30% of it to father so he can pay his phone bills from the prison. Again, if she wants to spend her money on talking to father, that's fine. But that's not to be spent on talking or facilitating conversations with the child. This child is in need of a lot of help. I read the Dr. Keck McNulty's testimony, and she talks about what's going to happen to these types of children who go through this level of violence when they're young. Now actually this is a bit off the point, but it's probably something that counsel in every capital case should be reading, because this environment presages later anger, later violence. And it's proved in this case, even in the short time while this case was pending, when that child was talking to father, he became violent.
Sorry, apologize.
When that child was talking to father, he became violent. When he wasn't, he improved. And mother, I'm not going to repeat a lot of what I said, but mother did not help this child. She actively worked against the child. That is the truth. She actively worked against this child making the progress that this child needs. So this permanent custody decision was eminently correct. It's not against the manifest weight of the evidence, and there's no cause to even think for a second about a 6-month extension. If there are no questions, I'm done.
There is a finding that the appellant raises about the trial court's finding that mother has a chronic mental health problem.
She does. I think the testimony from Dr. Victoria says this is a long-term condition. She has 2 diagnoses. She has the dependent personality. She has the antisocial personality disorder. Antisocial personality disorder is extremely hard to treat because that is a way of viewing the world from that person's perspective. That's extremely difficult to change. Now, Dr. Victoria said the mother needs continued counseling, and I know there was a comment from counsel that mother was doing really well. Well, that's not true. What Dr. Victoria said, that the mother's progress on the main point was problematic. So there's a lot of work to be done with mother. But mother's problems are not the child's problems. Okay, thank you.
I think the one thing that we want to focus on at this point is the fact that if the court finds the factors in 2151, 414E, that a finding that a child cannot be placed with either parent within a reasonable period of time or should not be placed with either parent and balance those factors, then they should remove the child from the home. In this particular case, with the chronic mental illness, the court did find chronic mental illness. One of the arguments is because Dr. Victoria said specifically that given that mother has made progress, it is possible that she would continue to do so. This is on page 57 of the transcripts. And that it is definitely possible for mother to overcome her diagnoses and problems. She also said that mother had been receptive to her treatment goals. Dr. Vittorio is the only mental health professional who was introduced at this trial. She would be the only person who would be able to give an expert opinion as to the chronic mental illness nature that mom had. She did not give that opinion. The finding that counsel speaks about was the parenting assessment evaluator who had completed that in December of 2013, nearly about 10 months before the PC case, and that person did not testify, did not take the stand. There was no discussion as to the nature of those types of illnesses. As there was no discussion as to the nature of those illnesses, many of the facts that counsel has brought forward are facts that are not in evidence, that weren't presented at the trial in this case, and I think that we need to be cognizant of what the trial court was looking at, the facts that the trial court was looking at when the trial court made the decision in this case, and some of those facts that were given as far as the background or what the child did, or that the child's behavior substantially increased, wasn't in the evidence in this case. As far as mother actively working against the child, there's testimony that this mom's interaction with the child was appropriate, that they were bonded, that she visited with the child. So mom's actions towards the child were not all negative. I think there is a policy issue of if a woman has been abused severely, has going through the cycle of violence, which was testified to, at some point in time she's got to learn to break that cycle. And both the caseworker and the counselor had said that she was making efforts. In fact, the caseworker said shortly before mother had made admissions to her that she had not about the abuse. This shows that mother was having some growth. She was beginning to understand what the harm was caused.
But that doesn't take into consideration, does it, the fact that, maybe your argument in regard to this particular case, if there wasn't a history, but that child was returned home with no contact from prior injuries that the father inflicted on the child. And it's one thing for mother, if she wants to take that risk, and she should be in counseling to overcome that for herself. But this has been going on for years with this child, and he was returned, and mom didn't protect him the first time.
And Your Honor, and I do understand that. I know that is part of what we see in the cycle of violence. Mom did not go through in that prior case plan the type of intense counseling that she was going through now, and so there wasn't necessarily as much of a breakthrough. And I do understand that maybe if the court gave her more time to see if she would have been able to go through and understand the type of harm, that maybe the state would have still filed permanent custody motion.
But my point is that this isn't a case in a vacuum. You have a history with this family.
Yes, I understand. I think, though, we could be a little critical of the timelines in the first case and whether or not there was real progress or whether or not the child might have been returned very quickly to that situation without growth. I think there's a difference between that first case and the growth that we were seeing mom going through in this case. I'm probably at the end of my time. Okay, thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision which will be mailed to both sides and posted on our website as well as the House Supreme Court website.